So here's the plan for our deep dive. We'll hit three main areas. First up, how the courts protect themselves. That's contempt of court. Then we'll look at the written word, restrictions on books and sedition. Think book bans, old laws, new laws.
Always a hot topic.
And finally, visual media, films and media regulation. Censorship, certification, all that. Ready to jump in?
Let's do it.
All right, topic 1. Contempt of court. So why do courts get this special power, this shield that maybe other branches of government don't quite have?
Well, it starts right in the Constitution with this idea of a court of record.
Court of record, okay.
Yeah, only the Supreme Court under Article 129 and the High Courts, Article 215, get this specific designation.
Constitutionally given.
Exactly. And that status inherently gives them the power to punish for contempt. It's separate from, any specific act like the Contempt of Court Act of 1971. It's baked into their status.
Okay, so what does being a court of record actually mean in practice?
Two key things, really. One, their decisions, their proceedings, they're kept forever. Permanent records. They have evidential value. You can't just question them lightly.
Right. Official record.
And two, the big one, the power to punish anyone for contempt of court. It's seen as necessary to make sure their authority isn't undermined, that orders are followed.
So the 1971 Act then comes along and defines the types. I gather there's civil and criminal contempt?
That's right. Civil contempt, it's relatively straightforward. It's when you deliberately disobey a court order or you break a formal promise, an undertaking you gave to the court. Pretty clear cut.
Okay. And criminal contempt. Sounds a bit murkier.
It is. It's much broader. Covers things like scandalizing the court, which is the really fuzzy one. Also obstructing justice or interfering with legal proceedings.
Scandalizing the court. That sounds incredibly subjective. How do you define that line?
That's exactly the problem. It relies heavily on interpretation. Did the criticism cross from fair comment into something that genuinely undermines the court's authority or imputes bad faith, big gray area?
Which brings us to a critical point for you, the listener, to think about. Why this power? Why let judges be, in a sense, the judge in their own cause when someone criticizes them?
Yeah, it seems counterintuitive. The rationale given is twofold: protection and independence.
Protection from what?
From, motivated attacks, not fair criticism of a judgment, but attacks aimed at damaging the institution's reputation, maybe accusing judges of bias without proof. And that ties into independence.
How so?
Well, the idea is if judges constantly fear personal attacks or undue pressure for their rulings, their ability to be objective, to be independent, could be compromised. And that independence ultimately serves the public, right? Not just the judges.
But still, that core issue remains. The principle of natural justice. Nemo judex in causa sua. No one should judge their own case.
Absolutely. It's a known tension. The judge is the offended party, the prosecutor, and the decision maker. It's why this power, while considered necessary, needs extreme caution in its use.
We know other places like the UK, US, they've largely moved away from scandalizing the court as a criminal thing.
They have, yeah. The UK example is quite telling. Remember that Daily Mirror cartoon?
Vaguely. Refresh my memory.
1987. The law lords, their top court then, made a controversial decision. The Mirror published a cartoon depicting them upside down, captioned, "You old fools." Yeah. And there was pressure to bring contempt charges. But Lord Templeton, quite a forward-thinking judge, basically said, well, I am old, and whether I'm a fool is a matter of opinion. He argued judges need thick skin.
So, a more robust approach to criticism. How has our Supreme Court guided judges here? To be less sensitive, perhaps?
Through judgments, yeah. The Melgonkar case back in '78 was key. The court explicitly said, use these powers sparingly, economically. Don't be hypersensitive. Balance judicial independence with public scrutiny.
And there was a big change in 2006, right, about truth?
Huge change. The Justification by Truth Amendment. This was crucial. Now, if you make an allegation against a judge or the court, and you can actually prove it with solid evidence, then truth is a valid defense against contempt. That's a major safeguard.
Okay, so that's the courts. Now let's shift focus a bit to the written word, how the state steps in there. Topic 2, restrictions on books and sedition.
Right, like banning books. Where does the government get the power to just say, this publication is forfeited, basically pull it from circulation? Yeah. That power comes from the Code of Criminal Procedure. It was Section 95 in the old CRPC. Now it's updated to Section 98 in the new BNSS, the Bharatiya Nyaya Sanhita.
And they can use this power if the book deals with certain specific offenses.
Exactly. It's not just anything they dislike. It has to connect it to specific legal violations. Things like Promoting enmity between groups, Section 153A. Or acting against national unity, 153B. Selling obscene material, 292. Or deliberately outraging religious feelings, 295A.
So the aim is to stop it getting out there. But you hear about this thing, the Streisand effect. Does banning actually work? Or does it sometimes just make things worse for the authorities?
Oh, it often backfires spectacularly. That's the Streisand effect in action. Barbara Streisand tried to hide pictures of her house, right? And suddenly everyone wanted to see them.
Right.
It's the same with books or other materials. The government bans something, announces it, and suddenly public curiosity is piqued. People who never would have heard of it go looking for it. Readership can actually increase. Remember the Satanic Verses ban? It became a global phenomenon, partly because of the attempts to suppress it.
Makes sense. Now let's tackle the really big one in this area, sedition. Section 124A of the old Indian Penal Code. What exactly did that law forbid?
124A. It was about bringing or trying to bring hatred or contempt or exciting disaffection towards the government established by law.
Disaffection. Sounds vague.
Extremely vague. And it was a classic colonial-era tool designed by the British really to crush the Indian independence movement. Gandhi famously called it the prince among the political sections, meant to suppress liberty. Nehru argued against it too.
Why was it so criticized beyond its origins?
Well, the vague terms like disaffection. Plus, it was widely seen as being used politically, to silence critics rather than address genuine threats. The conviction rate was notoriously low, often under 3%, suggesting it was used more to harass than to actually secure convictions for sedition. It felt like a relic of monarchy protecting the ruler, not the state.
But the Supreme Court didn't strike it down initially, did they? They interpreted it.
Correct. In a very important case, Kedarnath Singh versus State of Bihar, 1962. The court upheld the law's constitutionality, but they drew a critical line.
The violence line.
Exactly. They said, look, strong criticism, advocating for change, even radical change, that's protected speech. Sedition only applies when your words have the tendency or intention to incite people to violence or create serious public disorder. That distinction, advocacy versus incitement to violence, was crucial.
So where does sedition stand now, especially with the new criminal laws replacing the IPC?
Well, the old 124A was effectively put on hold by the Supreme Court in 2022 in the S.G. Vombakir case, pending review. Now, under the new Bharatiya Nyaya Sanhita, BNSS, Section 112A4A is gone. It's replaced by Section 152.
And what does the new Section 152 cover? Is it better?
It focuses more specifically on acts endangering sovereignty, unity, and integrity of India. Things like exciting secession, armed rebellion, subversive activities, and very importantly, it explicitly excludes criticism of government measures or actions. It says expressing disapproval without exciting those dangerous acts is not an offense. That's a significant clarification.
That seems like a positive step. Going back to book banning, though, for a second, should the government just be able to decide unilaterally this book is banned? Or should they need a court's approval first?
That's a key procedural debate. Right now, the government can issue the forfeiture order directly. But critics argue, and I think it's a strong point, that it would be better if the government had to go to court first.
Make their case.
Yes. Present evidence. Argue why the book violates specific laws, and get a judge to agree before the ban takes effect. It would introduce judicial oversight, a check on potential misuse of that power, more protection for expression.
All right, let's move to our third area. Visuals, sound, the big screen. Restrictions on films, obscenity, and media issues. This feels like where art versus vulgarity really comes into play. How do the courts even try to define that line?
It's tough, and the legal tests have evolved. There was an old, really quite archaic test called the Hicklin test. It came from 19th century England.
What was the problem with Hicklin?
It was incredibly broad. It basically judged material based on whether any part of it might tend to deprave and corrupt those whose minds are open to such immoral influences like children. It completely ignored the overall context or any artistic merit. A single passage could condemn the whole work.
So outdated. What's the modern standard? The Miller test.
Yes, the Miller test, which originated in the U.S. but influences thinking elsewhere. It's a 3-part test, and all 3 parts must be met for something to be legally obscene.
Okay, what are the 3 parts?
1. The average person applying contemporary community standards would find the work, taken as a whole, appeals to the prurient interest, basically, a shameful or morbid interest in sex.
Community standards. Tricky. Okay, 2.
2. The work depicts or describes, in a patently offensive way, sexual conduct, specifically defined by the applicable state law. So that has to be hardcore stuff, essentially.
And 3.
And 3. The work, taken as a whole, lacks serious literary, artistic, political, or scientific value. This is the crucial SLAPS test part. If it has serious value, even if it's sexually explicit, it's generally protected.
Got it. What about pornography specifically, viewing it?
Generally in India, viewing pornography involving consenting adults isn't itself an offense. The focus is usually on production and distribution. However, there's an absolute zero-tolerance line for child pornography.
Under the POCSO Act.
Exactly. The Protection of Children from Sexual Offenses Act, 2012. Possessing, viewing, distributing, creating any involvement with child pornography is strictly illegal and carries severe penalties. No ambiguity there.
Okay. Now, film certification. The CBFC Central Board of Film Certification. They give out the UAA ratings.
Right. Established by the Cinematograph Act of 1952. U is universal, A is adults only. And UA, which used to be just one category, has now been split.
Yes, the new categories.
Yeah, they introduced UA 7+, UA 13+E, and UA 16+8. So parents get more specific guidance about suitability for different age groups under 18.
But the CBFC itself, it gets a lot of flack, doesn't it, for acting more like censors than certifiers, demanding cuts.
That's been a persistent criticism.
Yeah.
That it engages in moral policing, asking for cuts based on subjective notions rather than just certifying content for audiences.
Yeah.
And historically, political interference was a major issue, too.
Governments trying to influence decisions.
Yes. But there was a significant ruling, the Shakarapa judgment in 2000. It dealt with the government's power under Section 6 of the Act to basically overrule the CBFC. The Supreme Court struck down that revisionary power. They emphasized that the CBFC is a statutory body meant to function independently. It shouldn't be subject to the government's day-to-day political whims or interference. Its decisions should stand unless challenged through proper legal channels.
Speaking of challenges, what's the situation now for filmmakers who disagree with the CBFC? Didn't they get rid of the appeal body?
They did, and it's a huge problem. They abolished the Film Certification Appellate Tribunal, FC8, in 2021.
It was FC8.
It was a dedicated, relatively quick and inexpensive quasi-judicial body where filmmakers could appeal CBFC decisions, refusals of certificates, or demands for cuts. Experts in film often sat on it.
So now what happens?
Now, filmmakers have no choice but to go directly to the High Court. That means significant delays, much higher legal costs, and judges who might not have specific expertise in film having to rule on these matters. It's a major bottleneck.
That sounds tough for filmmakers. Let's ask the structural question here. If you have the exact same message, say, critical of the government, why might it face tighter restrictions in a film than in a newspaper article? Why treat media differently?
That's a good question. And the law does allow for medium-specific restrictions. The rationale is usually based on impact and reach.
How so?
Well, firstly, in India especially, cinema has a potentially much wider, more immediate reach than print media, particularly among audiences who might not read newspapers. Secondly, the impact of audiovisuals is often seen as more direct, more visceral, perhaps bypassing critical reflection more easily than text.
And easier to take out of context.
Possibly, yes. Snippets, visuals, sounds, they can be powerful and potentially inflammatory if misused, raising concerns about immediate public order risks in a way that, say, a dense article might not. So the potential for greater restriction is acknowledged.
Okay, last point on films. The heckler's veto. This is when a film gets banned or pulled, not because of its content necessarily, but because some group threatens violence if it's shown.
Exactly. A small, vocal, sometimes violent group objects, and the authorities cite potential public order problems as a reason to stop the screening or ban the film. They essentially give in to the threats.
But is that legally sound if the film is certified?
The Supreme Court has pushed back against this. In the O. Gramley judgment, 1995, related to a controversial play, the principle was laid down. Once a film, or a play, has been cleared by the relevant authority, like the CBFC, the state cannot use the fig leaf, their words of potential public disorder, as an excuse to ban it.
So what should the state do?
Their job is to protect the filmmaker's right to expression and the public's right to see the film. They need to maintain order so that the film can be shown, not shut down the film to avoid trouble. They shouldn't submit to the heckler's veto. So we've covered courts, books, films, the mechanics of restriction. But let's pull back for the final section. Why does all this matter so much? Topic 4, significance and threats to free speech.
Right, the big picture. What's the fundamental value here? I always think of John Stuart Mill and the marketplace of ideas.
Mill's arguments are foundational, absolutely. He gave essentially 3 core reasons why suppressing speech, even speech we disagree with, is dangerous.
What were they?
First, he said, The opinion you're suppressing might actually be true. Society loses the chance to exchange error for truth. Think Galileo, the prevailing view is wrong.
Okay, makes sense. Second.
Second, even if the prevailing opinion is true, testing it against dissent makes it stronger. We understand why it's true better if we have to defend it. It prevents truth from becoming dead dogma.
So debate strengthens truth. And third,
and this is often overlooked, usually, both the prevailing view and the dissenting view hold part of the truth. Mill argued that truth is complex, multifaceted. Suppressing dissent means you almost always lose some important facet of the truth. Dialogue helps piece the whole picture together.
so allowing this free exchange, this marketplace, it leads to better outcomes.
Yes, it sustains collective life, allows dissenting groups to feel heard, part of the society. It fosters innovation, holds power accountable. It lets citizens, as they say, speak truth to power.
Which suggests a guiding principle when drawing lines.
The principle should probably be, it is better to err on the side of freedom. Meaning, if you have to make a mistake in balancing freedom and restriction, lean towards under-restricting rather than over-restricting. Choose the error that expands liberty.
Sounds good in theory, but in practice, free speech in India faces some serious headwinds, right? What are the main threats we see today?
Oh, definitely. There are several systemic challenges. One, we still have some of those obsolete British-era laws on the books, or their spirit lingers in new laws.
Like sedition used to be.
Exactly. Two, there's often a weakness or hypersensitivity in the political class towards criticism, satire. They don't always have the thick skin Lord Templeton talked about.
Okay, what else?
Three, a really worrying one, is the perceived weakness of media and publication houses. Sometimes due to ownership patterns, the concentration of media in fewer hands, what some call Murdochization. Owners might have other business interests that discourage aggressive reporting. Or sometimes just a lack of resources or willingness to back controversial writers or stories.
And the enforcement side.
Yeah. Four, problems with corrupt or politically influenced enforcement machinery. FIRs being filed to harass critics, often just to please political bosses, even if the case has no merit.
The process becomes the punishment.
Precisely, which links to five. The weakness of the judiciary in some aspects, particularly delays in hearing cases, granting bail. If you're arrested on flimsy charges but spend months in jail waiting for bail, your freedom is effectively curtailed even if you're eventually acquitted. And sometimes a reluctance to strike down problematic laws quickly.
And finally, the online world.
6. The pervasive culture of trolling and online toxicity, the sheer volume of abuse and threats can lead to a chilling effect, making people self-censor rather than risk the pylon.
Let's zoom in on the media's role for a second. You mentioned its weakness as a threat. Why is a strong, maybe even slightly adversarial media so vital?
It plays multiple crucial roles. It's the civic forum, the parliament of citizens, where public debate happens outside formal politics.
The watchdog role.
Absolutely the watchdog. Research consistently shows that higher media freedom correlates with better governance, lower corruption. That slightly adversarial stance isn't just inevitable, it's desirable for accountability.
And just informing people.
Yes, the informative role, ensuring the public knows what's going on, but crucially, also ensuring the government itself is informed. You mentioned the China salmon earlier.
Right, 1958-61. How did media suppression play a role there?
It was devastating. Because the media was suppressed and local officials feared telling the truth upwards, the central government in Beijing genuinely didn't grasp the scale of the starvation for far too long.
They were flying blind.
Essentially, yes.
Yeah.
A free press might have forced the issue, provided accurate information earlier, potentially saving millions of lives. It shows how media informs not just citizens, but the state itself, preventing catastrophic errors. And lastly, media helps in new value formation. It can shift societal priorities, making things like health, education, or the environment central political issues.
Okay, wow. We've covered a lot of ground. Let's try a quick, sharp recap to help lock it in. Key takeaways. First, contempt of court. Remember, Supreme Court and High Courts are courts of record, Art 129215. The big tension is nemo judex in causa sua.
Right, and key safeguards. The Malgonkar case advised to use powers sparingly, and the 2006 amendment allowing justification by truth as a defense.
Then restrictions on books and sedition. We talked about the power to ban, now BNSS 98, the Streisand effect. The old sedition law, 124A, was heavily criticized.
And crucially, the Kedar Nath case limited it to incitement to violence. The new BNSS Section 152 is narrower and explicitly protects criticism of government.
For films and media, remember the shift from the old Hicklin test to the three-part Miller test for obscenity. Big issue now is the abolition of FCAT, forcing filmmakers into costly high court appeals.
And don't forget the O'Gramley principle. The state must protect certified films, not give in to the heckler's veto.
Fundamentally, Mill's marketplace of ideas tells us why free speech matters, urging us to err on the side of freedom. But the threats are real. Old laws, political sensitivity, media concentration or Murdochization, enforcement issues, judicial delays, online trolling. So, a final thought for everyone listening.
I guess it's this. Free speech isn't really about having the right to just shout whatever you want or be deliberately offensive. It's more profound. It's about whether we, as a society, are willing to tolerate the uncomfortable truth, the challenging idea, the unpopular critique.
It takes maturity.
It does. It's a fundamental right, yes, but it needs constant defense, not just from courts, but from all of us. We have to stay vigilant to keep that space for dialogue open and protect its integrity.
A space essential for a healthy democracy. Thank you so much for joining us on this deep dive. Keep thinking, keep questioning. We'll see you next time.